The first thing I heard was the scream of a concrete saw behind my house. By the time I reached the backyard, a fresh gray slab had already swallowed part of the flower bed my father planted with me 6 years earlier. 2 steel survey pins were gone. Wooden forms cut across the edge of my property, and a crew was preparing to pour another section directly toward my workshop. Brad Mercer stood beside the mixer with a rolled set of plans under one arm, looking less like a neighbor and more like a man protecting conquered territory. His face was red, his jaw locked, and every movement of his hands was sharp and aggressive. Linda Graves, the HOA president, arrived seconds later carrying a folder stamped with the Oak Ridge Estates logo. She planted herself between me and the workers, as though a stack of HOA paperwork gave her authority over my deed.
Are you serious?
I ordered the crew to stop until the property line could be verified. Brad stepped forward, kicked one of my ceramic planters aside, and pointed toward the wet concrete as if the matter had already been decided. Linda backed him immediately, insisting that the addition had been approved and warning that the HOA could fine me for interfering with an authorized project. The foreman kept the mixer running. That was the moment I understood this was not a mistake. They knew the boundary was disputed, and they were rushing to finish the pour before I could prove it. I pulled out my phone and began recording. I captured the missing survey markers, the damaged flowers, the equipment sitting inside my yard, and Brad's expression when he realized I was documenting everything. He did not look worried. He looked amused. To him, I was just the quiet hospital technician next door, someone without the money, influence, or nerve to challenge a real estate broker backed by the HOA president. What Brad did not know was that I had already saved every email he ignored. He also did not know the county had no record of a permit for the 900-square-foot addition now crossing my property line. 2 weeks later, a red stop work order would be nailed to the front of his unfinished project. Before the case was over, the concrete he was pouring that morning would be broken apart, his contractor would be investigated, and Linda would lose the position she had used to threaten me. But as I stood there watching wet concrete creep closer to the last chair my father ever sat in, I still had no idea how deep their lie went. 6 years before Brad Mercer poured concrete across my property line, I bought that house because it was the first place that ever felt completely mine. It was not large or impressive. The siding needed work, the kitchen looked 20 years out of date, and the backyard sloped slightly toward a line of mature oaks. But it sat at the end of a quiet cul-de-sac, and behind the house was enough space for a small workshop, a vegetable patch, and a place where my daughter Lily could play without traffic rushing past. I was 33 then, newly divorced, and working long shifts as a medical equipment technician at the county hospital. My job was not glamorous. Most days, I repaired infusion pumps, patient monitors, and machines nobody noticed until they stopped working. It taught me to stay patient, document every failure, and never assume that the loudest person in the room understood the problem. My father, Thomas, helped me repair the house during that first summer. He replaced broken deck boards, built shelves inside the workshop, and planted a row of blue hydrangeas along the side yard. Near the far end of the flower bed, he pointed out an old iron survey pin partly hidden beneath the soil. He told me never to remove it because it marked the legal boundary, even though the decorative fence stood several feet away. At the time, I barely thought about it. My father died 2 years later. After that, the workshop and the garden stopped being ordinary parts of the property. His tools were still arranged on the wall in the order he preferred. The wooden chair beside the hydrangeas was where he used to sit when his knees hurt. On quiet evenings, Lily and I would sit there together, and I would tell her stories about the grandfather she remembered only in fragments. That small strip of land mattered because it held more than soil. It held the last physical evidence of a life I did not want erased. For years, there was no conflict. The previous owners next door understood that the fence was decorative and that the true property line followed the recorded plat. We both maintained our own side, and nobody cared about the narrow open space between us. Then Brad Mercer bought the house. Brad introduced himself as a real estate professional before he even told me his name. Within weeks, he was talking about resale value, luxury upgrades, and how Oak Ridge Estates had been undervalued because too many residents resisted change. He replaced the patio, removed several trees, and began hosting large weekend gatherings for clients and HOA board members. At first, I tried to be friendly. I helped him reset a tripped outdoor breaker and once moved my truck so a delivery vehicle could access his driveway. But Brad treated every favor as proof that people would eventually move aside for him. When he first mentioned the addition, he described it as a modest renovation. Later, I saw stakes stretching toward my flower bed and realized the project was anything but modest. He planned to add nearly 900 square feet, an outdoor kitchen, a retaining wall, and a wide concrete patio around a new pool. I reminded him that the fence was not the legal boundary and suggested that he order a certified survey before construction began. Brad dismissed the concern without checking anything. He believed the HOA approval mattered more than an old deed, and Linda Graves was willing to encourage that belief. Linda had been HOA president for nearly 4 years. She liked polished mailboxes, matching paint colors, and residents who obeyed without asking questions. Brad had helped her sell 2 investment properties and had donated money toward renovations at the HOA clubhouse. Their relationship gave him the one thing he valued most, the appearance of authority. I sent Brad a polite email asking for a copy of the survey and site plan. He never answered. Linda responded instead, saying the board had reviewed the project and found it consistent with community standards. That answer bothered me because community standards had nothing to do with ownership. Before we continue, leave your opinion in the comments. Should an HOA ever approve construction near a property line without requiring a certified survey? Share this story with anyone dealing with a similar dispute, save it in case you ever need the reminder, and subscribe for more stories where paperwork matters more than intimidation. 3 days after Linda's email, I noticed fresh paint marks near the hydrangeas. The old iron survey pin my father had shown me was gone. By the following Monday, Brad's project had stopped looking like a renovation and started looking like an occupation. A temporary construction fence appeared along the side of my yard before sunrise. It did not follow the decorative fence or the visible landscaping. It curved inward around my hydrangeas, cutting off the corner where my father's chair sat and blocking the narrow path to my workshop. When I moved closer, I saw fresh wooden stakes driven deep into the soil. Orange paint marked a line nearly 3 feet inside the area shown on my deed. The site supervisor, Jason Pike, stood beside an excavator checking measurements on a tablet. I told him the layout crossed my property line and asked to see the certified survey used for the project. Instead of producing one, he showed me a printed site plan with an HOA approval stamp in the corner. The plan treated the decorative fence as the legal boundary. I explained that the fence had never marked the recorded line. Jason barely looked at me. He had been told the design was approved, the concrete trucks were scheduled, and every hour of delay would cost his company money. My ownership was being treated as a scheduling problem. Brad arrived a few minutes later in polished shoes that immediately sank into the wet soil. He walked along the construction line with the confidence of someone inspecting property he already believed belonged to him. When I showed him a copy of the plat on my phone, he refused to examine it. He had HOA approval, a contractor, and enough money to finish the project. In his mind, that settled everything. I contacted the sheriff's office before the situation could escalate. The deputy who arrived was calm and professional. He photographed the stakes, recorded my complaint, and gave me an incident number. But without a current certified survey in front of him, he could not determine the exact property line or order the crew to leave. He explained that boundary disputes were generally civil matters unless there was clear evidence of another crime. Brad listened from several feet away. The moment the deputy drove off, his expression changed. He treated the absence of an arrest as proof that he had won. The workers restarted the excavator, and the bucket tore through the edge of my flower bed. By noon, several hydrangeas had been ripped from the ground. Gravel covered the path to my workshop, and deep tire tracks cut across the lawn. The crew removed 2 old metal markers they claimed were scrap and stacked them beside the debris. By the time I reached the pile with my camera, both markers had disappeared. The next morning, a concrete truck backed through the side access area. Its rear wheels crossed the edge of my driveway, cracking a section near the drainage channel. Workers poured footings along the disputed line and installed forms so close to my property that I could no longer reach the side wall of the workshop without stepping into their work zone. I photographed everything from inside my yard. I recorded timestamps, license plates, employee names, and equipment numbers. I also sent Brad and Linda a written notice explaining that the property line was disputed and that continued construction could increase their liability. Neither of them stopped the work. Linda responded with a formal HOA violation notice. According to the notice, I had interfered with an approved architectural improvement, created an unsafe condition near a construction site, and behaved in a manner inconsistent with community standards. The board imposed an initial fine of $500 and warned that an additional $100 could be added for every day I obstructed the project. The notice did not mention my deed, my missing survey markers, or the concrete forms sitting on my land. I requested an emergency hearing before the HOA board. Linda scheduled it for that evening in the clubhouse, but the meeting was never intended to be fair. Brad sat near the front with his contractor. Two board members appeared uncomfortable, while Linda controlled the agenda and refused to let me display the recorded plat. She treated the HOA's architectural approval as though it were a court ruling. She insisted the board had reviewed the project and accused me of trying to delay improvements that would raise property values throughout the neighborhood. When I tried to explain that an HOA could approve the appearance of a project without owning the land beneath it, Linda ended my time and ordered the security guard to escort me from the room. Outside the clubhouse, Brad passed me with the satisfied expression of a man who believed procedure belonged to whoever controlled the meeting. The crew returned early the next morning. They poured the first major section of concrete before I could reach the backyard. Wet cement filled the forms beside the hydrangeas and covered part of the gravel area where my father had once stored lumber. The slab extended toward the workshop like a gray platform pushing deeper into my property. Then the weather changed. A heavy storm rolled through Oak Ridge that evening. Before construction, rainwater had flowed gradually along the side yard and into a drainage swale behind both houses. Brad's excavation and retaining wall forms blocked that route. Water collected behind the new concrete, spread across my lawn, and rushed under the workshop door. By the time I reached it, several inches of muddy water covered the floor. Cardboard boxes had collapsed. Electrical tools sat in brown water. The bottom shelf my father had built was already swelling and separating from the wall. I filed another report, contacted my insurance carrier, and sent Brad photographs of the damage. His response came through Linda. The HOA considered the flooding a result of natural weather and denied any responsibility. That night, I sat inside the damaged workshop, reviewing security footage frame by frame. I expected to find images of the crew crossing my yard or removing the flowers. Instead, at exactly 5:17 on the morning construction began, the camera captured Jason kneeling beside the hydrangeas. Brad stood behind him, lighting the ground with his phone, while Jason pulled a metal survey pin from the soil. They had not mistaken the property line. They had removed the evidence of it. The video changed everything, but I knew it would mean nothing if I handled it carelessly. I stopped contacting Brad directly. I stopped arguing with Linda. I stopped trying to convince people who had already decided that authority mattered more than ownership. From that point forward, I treated the dispute the same way I treated a failed medical device at the hospital. Preserve the evidence, document every step, and never alter the scene before the cause could be verified. I copied the security footage onto 2 external drives and uploaded a third copy to encrypted cloud storage. I saved the original files with their timestamps intact, then created separate clips showing Jason removing the survey pin, Brad holding the light, and both men walking back toward the construction area. Next, I built a timeline. Every email, photograph, HOA notice, weather report, invoice, and camera clip went into a folder labeled by date. I included the first message, in which I warned Brad that the decorative fence was not the legal boundary. I saved Linda's response, claiming the HOA had approved the project. I added the certified mail receipt, proving that both of them had received written notice before the concrete was poured. I photographed the damaged workshop from every angle. The waterline on the walls, the swollen shelving, the ruined tool cases, and the mud trapped beneath the workbench were all recorded before I cleaned anything. My insurance adjuster inspected the damage and noted that the flooding pattern appeared consistent with a recently obstructed drainage path. Then I went to the county clerk's office. The property records were older than the neighborhood around them. My parcel had been created before Oak Ridge Estates expanded, which explained why the decorative fence did not match the recorded boundary. The deed referenced a subdivision plat with measurements tied to permanent county monuments rather than landscaping or fence posts. The plat showed the line bending slightly near the rear of the property. At the widest point, my land extended almost 3 feet beyond the fence. I ordered certified copies of the deed, plat, parcel history, and recorded easements. I also requested the planning files for Brad's property and every permit connected to his address during the previous 18 months. The permit search raised another problem. Brad had approval for interior remodeling and a residential swimming pool. There was no issued permit for a 900-square-foot home addition. There was no separate approval for the retaining wall, and no drainage plan had been filed for the concrete patio changing the direction of runoff between the two properties. One permit number appeared on a contractor document visible in my camera footage. When I searched it, the number belonged to a roof replacement 3 streets away. That discovery was serious, but I still needed someone qualified to establish the boundary. I hired Ethan Cole, a licensed surveyor with more than 20 years of experience in county boundary disputes. He arrived with GPS equipment, a robotic total station, metal detectors, and copies of the original plat. He did not begin by looking at the fence. He located the county reference monuments, verified the recorded bearings, and worked inward toward my parcel. For nearly 4 hours, Ethan measured points along both properties. He found one original marker buried beneath mulch near the front corner. At the rear, he located disturbed soil where another monument should have been. The metal pin visible in my security footage matched the location described in the recorded survey. When Ethan placed the new flags, the result was impossible to ignore. Brad's concrete crossed onto my land by more than 30 inches in several places. One corner of the new foundation extended over the property line. Even the portions remaining on Brad's parcel appeared too close to the boundary to satisfy the county's required side setback. The retaining wall forms created another violation. They blocked the historic drainage swale and redirected stormwater toward my workshop. Ethan prepared a certified boundary survey showing the encroachment, missing monument, setback measurements, and affected drainage area. He warned me not to move any construction material or attempt to remove the concrete myself. The survey needed to remain connected to an undisturbed physical record. I followed that advice. My next call was to Rachel Kim, a real estate attorney who specialized in boundary disputes, HOA conflicts, and construction encroachments. I sent her the deed, plat, survey, permit records, camera footage, HOA notices, insurance report, and the full email chain. Rachel identified the pattern immediately. This was not simply a contractor measuring from the wrong fence. Brad had received written notice of a disputed boundary. The survey marker had been removed before construction. The HOA had continued threatening me after being told ownership was contested. The crew then poured concrete without confirming the legal line or producing a valid building permit. Rachel sent preservation notices to Brad, Linda, the HOA management company, and the contractor. The notices required them to retain emails, text messages, plans, meeting records, security footage, permit applications, and communications concerning my property. She also sent a formal demand letter ordering them to stop all work within the disputed area, restore drainage, and provide proof of insurance. Brad ignored the deadline. Construction continued the next morning. That decision gave Rachel exactly what she needed. We assembled an evidence packet for county code enforcement containing the certified survey, the permit search, dated photographs, insurance findings, video of the removed marker, and copies of the warnings Brad had received before continuing the work. By then, I was no longer trying to make Brad admit he was wrong. I was preparing to let the county prove it for him. The final piece arrived that evening when Ethan emailed the completed survey. The new property line did not merely cross the edge of the patio. It ran directly through the corner of Brad's foundation. Rachel did not begin with the concrete. She began with the authority Brad and Linda had been using like a shield. The HOA's approval letter looked official. It carried the Oak Ridge Estates logo, Linda's signature, and language stating that Brad's addition had been reviewed and accepted under the community's architectural standards. Brad had waved that document in front of workers, deputies, and neighbors as though it gave him the right to build wherever he wanted. But the HOA bylaws said something very different. Rachel found the limitation buried inside the architectural review section. The board could approve exterior appearance, materials, color, roof design, and compatibility with the neighborhood. It could not certify legal ownership, establish a property line, waive a county setback, or authorize construction on someone else's parcel. The approval letter was not proof of Brad's rights. It was proof that Linda had approved a project without verifying whether the HOA had any authority over the land beneath it. The permit records created an even larger problem. Brad had repeatedly claimed that the county approved the entire addition. In reality, the county had issued permits for interior remodeling and the swimming pool. The 900-square-foot structure shown in his plans had never received final approval. Neither had the retaining wall that redirected stormwater toward my workshop. The permit number printed on one of the contractor's documents belonged to an unrelated roofing project 3 streets away. Rachel compared the false number, Brad's site plan, and the county database. The site plan showed the decorative fence as the legal boundary, even though the recorded plat placed the line nearly 3 feet farther into Brad's yard. That false boundary created enough artificial space for the addition to appear compliant with the required setback. Without it, the project could not legally fit where Brad wanted it. The lie was not hidden in one place. It had been built into the entire design. Then Rachel reviewed the security footage again. The video showed Jason removing the survey pin before sunrise. Brad stood behind him, illuminating the ground with his phone. After the pin came out, both men remained beside the empty hole for several seconds before carrying the marker toward the construction area. Their actions matched the exact location Ethan later identified from the original plat. Brad could no longer claim that he had trusted the fence by mistake. He had stood over the legal marker while it was being removed. Maria Alvarez provided another piece of evidence from her doorbell camera. Linda's vehicle had arrived at Brad's house before 6 that same morning and remained there for almost 40 minutes. Her camera did not capture what happened inside, but the timing placed Linda at the property immediately before the crew began working across the disputed line. Rachel then received the HOA's records in response to the preservation notice. One email changed the case. The night before construction began, Linda had warned Brad that I might order a survey and challenge the boundary. Instead of telling him to pause the project, she encouraged him to finish the concrete work before I could cause further delay. She also told the management company to prepare a violation notice against me if I interfered. That email connected everything. Linda knew the property line was disputed. Brad knew a legal marker existed. The contractor knew no certified survey had been provided. Despite that knowledge, they removed the marker, continued construction, and used HOA fines to pressure me into staying silent. Rachel explained that intent mattered. A simple surveying mistake could sometimes be corrected through negotiation, insurance, or a boundary agreement. Continuing after written notice was different. Removing a known marker and rushing to pour concrete before the owner could obtain a survey made the conduct appear deliberate. The insurance carrier noticed the same distinction. The contractor's policy covered ordinary negligence, but intentional acts and knowing violations could be excluded. The moment the carrier saw the footage, it opened a separate investigation into whether Jason and the company had knowingly participated in an encroachment. Brad's project was now exposed from every direction. The foundation crossed my deeded property. The addition violated the county setback. The retaining wall altered drainage without approval. The permit number was invalid. The HOA lacked authority to approve ownership rights. The contractor had removed a boundary marker after receiving notice of a dispute. Even Linda's $500 fine became evidence. It showed that the HOA had attempted to punish the legal owner for objecting to unauthorized construction. Rachel assembled everything into a single evidence packet. The front page contained Ethan's certified survey. Behind it were the county plat, permit search results, photographs, insurance findings, HOA bylaws, the false permit document, camera stills, and the email showing Linda's instructions. The packet went to county code enforcement, the building department, the HOA's insurance carrier, and the contractor's licensing board. For weeks, Brad had controlled the situation by moving faster than I could respond. He poured concrete before I could get a survey, brought Linda into every dispute, and treated each completed stage of construction as something nobody would dare undo. But concrete did not make an illegal project legal. It only made the violation more expensive. The next morning, Brad scheduled the final pour for the rear section of the addition. The trucks were already on their way when Rachel received a call from the county. An inspector had reviewed the evidence. Code enforcement was coming to the property before noon. The first concrete truck arrived at 10:42 that morning. By 10:55, Officer Jenkins from County Code Enforcement was standing beside it with a clipboard, a camera, and a copy of Ethan's certified survey. Building Inspector Mark Ellison arrived a few minutes later and went directly to the permit box attached to Brad's temporary construction fence. Brad came out of the house carrying the HOA approval letter. Linda arrived almost immediately after him. For weeks, that document had ended every argument. Linda had used it to threaten me, Brad had used it to pressure the contractor, and the crew had treated it as permission to keep working. Mark read the first page, looked at the construction site, and handed it back. An HOA architectural approval was not a building permit. It did not establish a property line, waive a setback, or authorize construction on another owner's land. Ethan placed bright orange flags along the surveyed boundary. The line cut through the edge of the patio, crossed the concrete footing, and passed directly through one corner of the unfinished foundation. The crew went silent. Mark measured the distance between the foundation and the legal property line. Even where the structure remained on Brad's side, it failed the required setback. He then checked the retaining wall and confirmed that it had been built without an approved drainage plan. Officer Jenkins compared the permit number displayed by the contractor with the county database. The number did not belong to Brad's addition, it belonged to a roofing job on another street. Brad tried to blame the contractor. The contractor blamed Brad's site plan. Linda insisted the HOA had relied on the documents Brad submitted. For the first time, the three people who had stood together against me were no longer protecting one another. Mark photographed the foundation, the missing drainage channel, the concrete extending across my property, and the false permit information. Then he removed a red notice from his folder and attached it to the front construction barrier. The words were large enough to read from across the yard. Stop work order. All construction had to cease immediately. No concrete could be poured. No forms could be removed. No soil could be moved, and no part of the disputed area could be covered or altered until the county completed its review. The order required Brad to submit a corrected site plan, obtain valid permits, restore the drainage route, and explain how construction had crossed a certified property line. The concrete truck left without unloading. Jason attempted to remove several tools from the disputed area, but Officer Jenkins told him the scene needed to remain undisturbed. The sheriff's deputy who had responded earlier returned and added the survey footage, the missing marker, and the continued trespass to the official incident report. By the afternoon, the contractor's insurance carrier had opened a formal investigation. The state licensing board also requested copies of the permit documents and security video. The conflict moved beyond the backyard that evening. At an emergency HOA meeting, Rachel presented the certified survey, Linda's email, the violation notice issued against me, and the permit search results. Residents who had previously accepted Linda's version of events began asking why she had approved a major addition without a survey and why HOA resources had been used to defend Brad's private project. Linda lost control of the room. She slammed her folder onto the table and blamed the contractor for using the wrong permit number. Brad responded that Linda had assured him the board would handle any objection. The contractor's representative then produced messages showing Brad had ordered the crew to finish the pour before my survey could be completed. Their alliance collapsed in less than 10 minutes. Before the meeting ended, Mark sent Rachel his preliminary finding. The encroaching concrete could not simply be trimmed at the edge. The footing, patio, retaining wall, and drainage system had been designed as one connected structure. Correcting the violation could require Brad to remove almost everything the crew had built. The project he had rushed to make permanent had just become the most expensive evidence against him. The county's final order arrived 11 days later. Brad was required to remove the encroaching foundation, the connected patio, and the retaining wall that had redirected stormwater into my workshop. Because the system had been poured as one structure, the damage could not be corrected with a narrow cut along the property line. Most of the work had to be demolished and rebuilt from the beginning. The removal alone cost him nearly $78,000. Restoring the drainage channel and stabilizing the soil added another $24,000. His insurance dispute, legal fees, permit penalties, engineering revisions, and construction delays pushed the total loss far beyond what he had expected to gain from the addition. Under the settlement, Brad also paid $12,500 for the damaged hydrangeas, cracked driveway, flooded workshop, and ruined tools. He reimbursed my survey and legal expenses, including the cost of proving a boundary he had already known existed. The contractor was removed from the project. Jason lost his job after the security footage confirmed that he had pulled the survey marker from the ground. The state licensing board opened a disciplinary case over the false permit number and the decision to continue working after written notice of a boundary dispute. The consequences reached the HOA as well. Every fine against me was canceled. The board reimbursed the fees I had spent responding to Linda's violation notices and placed all future architectural approvals under a stricter review process. Any project planned near a property line would now require a certified survey before the HOA could consider it. At the next public meeting, the board voted Linda out as president. Residents who had once accepted her decisions without question demanded access to the emails, legal invoices, and records connected to Brad's project. Her authority disappeared almost as quickly as the concrete she had tried to protect. For several months, Brad's backyard remained a field of broken slabs, exposed soil, and orange inspection flags. The luxury addition he believed would raise his home's value became a daily reminder of what arrogance had cost him. I did not celebrate in front of him. I used part of the settlement to repair the workshop and rebuild the shelf my father had made. I replanted the hydrangeas along the certified property line and returned his wooden chair to the same quiet corner of the yard. The new survey pins were clearly marked, photographed, and recorded with the county. Brad had tried to win by moving quickly, speaking loudly, and surrounding himself with people who looked powerful. I won by preserving video, saving emails, checking the deed, hiring a licensed surveyor, and refusing to destroy the evidence in anger. A fence can be moved. A survey pin can be buried. An HOA letter can be waved around like a weapon. But none of those things can rewrite a deed. Share your opinion in the comments about who carried the greatest responsibility: Brad, Linda, or the contractor who kept building. Send this story to anyone facing a property line dispute. Save it as a reminder to document everything, and subscribe for more stories where patience, evidence, and the law finally force the truth into the open.